Okay, I'm here with Michael Popok of Zupano, Patricius, and Popok. How are you?
Doing well, Ben. How are you?
Good. Have you seen the meme online of Britney Spears and which stage of Corona you're on? One is Britney Spears in high school, and then by the time it's like 5, 6, 7, 8, she starts looking like the Britney Spears who had the umbrella and she's uh,
The bald,
destroying the car.
the bald version of Britney with no underwear. That one.
Yeah. What stage in the Britney Spears meme are you right now?
I'm not in high school any longer, but I'm not yet where I'm driving my toddler around on my lap with no seatbelt.
Yeah,
So
I think I'm 7,
somewhere in
maybe
between.
just beginning my excursion into methamphetamine, and so
Yeah,
I'm right around 6 or 7 right now.
it's like Castaway. Like I don't have Wilson yet, but he's on his way.
I hear you. So we're here to do a legal rundown. There's been a lot of crazy, interesting cases that have not been covered during the coronavirus pandemic, some related to coronavirus, some not. And I thought it would be great to discuss these with you, get your input for everybody out there. And I think we start with the article you wrote today about this is corona pandemic related, which is, are these quarantine and lockdown orders constitutional? And what say you? What was the thesis of your article that you published today for Midas Touch?
Yeah, yeah. Thanks for raising that because it's really been bothering me. On one hand, you've got the public health crisis, and you've got local, state, federal officials trying to figure out how to stop the spread of the pandemic. But on the other hand, you've got that stubborn thing that's called the U.S. Constitution, and there are certainly things that public health officials and the CDC can do to stop infected people from infecting other people, even across borders. But we've sort of lost sight of the Constitution and the ability of individuals who reside in one state to freely travel and be in interstate commerce and provide goods and services in another state. And the Trumps of the world and even governors are acting like there is no Constitution. A governor in Rhode Island can say, we are going to be an island unto ourselves. And if you're from a neighboring town or a neighboring state like New York that may have a higher level of infection, we're gonna lock our doors to you, and we're gonna pull you over with our state police and send you home. And I don't think the Constitution allows for that. So the thesis of my article was, just as whenever there is an epidemic, a pandemic, or a panic, whether it was in World War II with Japanese Americans maybe being traitors and we need to put them all into a camp and make sure we can keep an eye on them, Supreme Courts then have to look at what did we do during that period, and was it consistent with our rights under the Fourth Amendment and under the main umbrella of the Constitution when it comes to freedom of travel. I'm not just a resident of New York, I'm a citizen of the United States. And unless I'm infected and causing the contagion to be transmitted, I should be able to go to New Jersey, Connecticut, Rhode Island, or California, or anywhere else.
We're seeing here too in California the rights of prisoners, incarcerated persons to have their arraignments heard, the right to a speedy trial. All of these are being delayed, under the heading of this is a national emergency. But at the end of the day, you don't suspend the Constitution. And the craziest part, at least as litigators, is what we're doing right now through Zoom. You don't need to be physically in a courtroom to have an arraignment. I think I've seen in Florida that sometimes they broadcast ones that are somewhat humorous of people having arraignments, and sometimes they're cursing out the judge, and you see some of the video arraignments there. But why don't we have technology of the 21st century in courtrooms? I think this is a big wake-up call. What do you think?
Yeah, I agree with that. I think there's been a number of law firms, especially in New York, that have actually come to your home state in California. I know one in particular that just got out of ICE. 2 detainees that were allegedly infectious, that were being denied fundamental constitutional rights. Look, we have a pandemic. We have a public health crisis that modern era has never known. But that does not mean we take into the street the Constitution and set it afire and figure it out later. It has to be at the same time. The ethics and constitutionality of what we're doing has to be considered by the federal government and the state and local officials at the same time. I don't want to hear, well, they locked me up because they were worried I was going to infect my neighbor. Oh, a year from now, a Supreme Court says, oh, you shouldn't have been locked up, Mr. Popok. That was wrong. I think this needs to be done now. Federal courts need to be prepared, whether it's by video technology or otherwise, to hear these issues now.
And as far as I know, when I've looked at the stimulus package, I didn't see enhanced electronic equipment in federal courts as one of those things. You would think that would be a top priority, but I didn't see that.
Yeah, that's a very, very interesting observation. All of the people that are in my world, and you're one of them, are scratching their head about how is this going to be, or is this going to be a paradigm shift of how we operate legally in the law and in business after the pandemic subsides. And one thing I know for sure, what used to be the business continuity plan that was in the desk drawer that nobody ever looked at, it was mothballed, is now going to be a living, breathing document. Every company, every litigant, every law firm is going to have to, every month, every 6 months, review and update their business continuity plan and use these different technologies that you're talking about. And the court system has to lead on this and not be lagging behind. They should be the ones that are promoting Zoom being used in the courthouse and electronic presentation of cases during times of national crisis or quarantine. Otherwise, what do we have left? We're locked down in our homes by the federal and state local officials. We don't have access to the court systems. I mean, that sounds awful lot like the dictatorships that we often claim that we're not anything similar to.
Yeah, and I would argue if you don't have business continuity plans, especially with the wake-up call we have, your corporation, your law firm is being negligent, essentially per se. And one take I want to have, and I have a question for you about video depositions. I've been asked on video mediations.
Yeah.
My own personal view is for a deposition of a party. I always felt that I need to be there. I need to see their reactions. But then I also thought that I need to have a BlackBerry and didn't want to go transfer to the iPhone for that period of time. So is this a BlackBerry iPhone kind of thing, and we could take video depositions and just need to stop being so freaking stubborn? Or is there something to being there and looking at the person's pupils and saying, you're a liar?
I like to be in the room with my party at a deposition. However, I think with the advent of very sophisticated communication platforms that are as stable and reliable as what we're on right now, in this case Zoom or Google Hangout or anything else, I can be just as effective. And you have to believe this as a lawyer, that you can be just as effective having the person directly across from you by video box as in the room. If you do international practice, which I know you do as well, it's very commonplace to have the head of the company in London or in Paris or Madrid, especially now with the pandemic and travel issues. You have them on your video screen. You don't have the luxury of having them in the room. And lawyers like you and I are just going to have to figure out how to be just as effective and just as tenacious through video box to video box as we were breathing on our deponent.
Yeah. And if I were to do that, though, I feel like I would need a camera to give me occasionally a 360-degree view. So there's no Houston Astros throwing signs or cheating behind the scenes and giving notes to the deponent. I need to make sure that I'm really talking. But with that, I tend to agree. Let's move on to the next topic. And the next topic is, I've read about these dueling class action lawsuits. I think they've been brought in Florida. At least one's been brought in Florida against China. I saw one headline that one group of lawyers is seeking $20 trillion. I think that's the biggest ask I've ever seen in any case whatsoever. If they were on a contingency, that would be fantastic. You'd get an $8 trillion contingency payoff and you never have to work again. I think it's a great headline. It's great to, I guess, be angry at someone right now, but is there merit to these lawsuits? I know that there's a ton of issues regarding the sovereignty of other countries. Is this a lawsuit that's looking for a headline, or is this a lawsuit looking for a jury?
I think it has an ability to get to a jury. Let me tell you why. I took a look briefly at the lawsuit that was filed in Miami. I practiced there as well. And I happen to know the judge this one's been assigned to, which is Judge Ungaro, who's very, very, very good. Side note, she actually was a plaintiff in a case about 15 years ago. She discovered that she was Jewish late in her life and went after some Nazi gold money. So she has an interesting backstory. She's a very good judge for this. She's very smart. She's very tenacious. But more importantly, I think they have the underpinnings for a quality case. Let me tell you why. I think it's based on the exemptions to sovereign immunity and the sovereign immunity law that were developed during the Chinese drywall set of cases. For those of our viewers who don't know about that, 15, 20 years ago, there was just a series of cases throughout the country and in multi-district litigation focused on defective drywall being bought from China that was inadvertently installed in homes all over America. It was defective in ways that made people ill. It gave off gases and other things that made people ill. And it had to be literally, after construction, ripped out of the houses and replaced at hundreds and hundreds of, not millions of dollars per house. And so there was an exemption that was eventually established that if there's a personal injury component to the sovereign actor, the government outside of the United States, and it has an impact on the personal safety or health of people within the United States, then they're not exempt under sovereign immunity law. And I think that is the page or the playbook that the current case is based on. I think it's going to be tricky. You're going to have to prove that the health and public health policies of China, especially in the very beginning in the Wuhan district, were more interested in hiding the problem from the greater world, as the communist China is prone to do, rather than address with vigilance the health problem. And they allowed, and I think they've recently found what they think is patient zero, a woman who worked in the Wuhan open fresh market, if you will, who had cold symptoms which became coronavirus. And they literally think this one woman might have infected or started the whole Wuhan contamination. But if they can prove that in that month, around the Chinese New Year, when everybody was flooding into Wuhan because of the New Year, who got infected and then circled out through Europe, through New York, and everywhere else, it's because of ineffective and negligent public health policy. I think they can get past the motion to dismiss and take a case to a jury.
And so you wouldn't actually have to show under that scenario that Chinese people or the China created it in a lab. You wouldn't have to show just merely their negligence and how they administered their health policy and the damages it caused. Here's enough.
Exactly right. I don't think you have to show that there's some secret lab and this was germ warfare. I think you have to show that their response to the public health crisis was insufficient and infected the world.
Well, another interesting part of that would be, I wonder if there would be an argument for contributory negligence as well, both in terms of how our governments responded, both at a federal and state level, and then even on a multinational level, in terms of Europe's response, Italy's response, and how the world responded. So if you were apportioning liability, which is what contributory negligence focuses on, it would probably be the longest jury verdict form in the world over every single potential entity that's also responsible.
Look, to remind our viewers, it was just 5 weeks ago or so that Trump thought that if he kept a shipload of people off the coast of California from coming into the country, all of his pandemic problems would be solved. And that's when we had 50 people total in the entire country. That was 6 weeks ago. And look at the numbers now. So yes, I think from a comparative or contributory negligence standpoint, certainly there's going to be an argument by the Chinese government that, hey, it wasn't our failing. It was the failing of the world public health policies and the leaders, not just us.
So moving on to China, as Trump calls it, to little Mike Bloomberg, as also Trump calls it. There's a class action lawsuit that was just filed against Mike Bloomberg and the Bloomberg campaign. The essential allegations were that Bloomberg promised his campaign staffers that they would be fully employed through the election in November. He stopped paying them, and they banded together and filed the class action. First off, why would he stop paying them? I mean, it's just such a bad PR look for someone who has the ability to pay them. I can't imagine it's more than a few $1 million in payroll, which is just a few ads that he was taking out. Why do this in the first place? And two, what do you think about the class action lawsuit?
Yeah, I was shocked by it. I was shocked by that he would allow this to be filed and wouldn't have resolved it with them. I mean, it was almost the same week that Bloomberg Philanthropies announced this huge COVID-19 municipal government, hundreds of millions of dollar program. I mean, he has. There's one thing about Mike Bloomberg. He is tone deaf in certain areas. We saw it during the debate. He spent almost $1 billion of his own money on his campaign, but the best he could come up with on the debate stage when asked about sexual harassment and discrimination in his own company was, well, I told a few off-color jokes and they didn't get it. I mean, he does have a quality for all of his great accomplishments and contributions as a philanthropist. He has this tone-deaf quality.
It was so frustrating to him that he had nobody to blame on that one but himself. I mean, he was poised. The campaign strategy was actually brilliant. He could have moved into the lane that Biden took right at that perfect time. They sequenced it perfectly. But boy, Elizabeth Warren killed him. And it wasn't even killing him with something that was unpredictable. Of course you're going to get up there and you're going to be asked about this. And the first thing you say is, I'm going to open up. I'm not going to keep the non-disclosure agreements. You're going to run and not expect that.
Yeah, her big contribution to the campaign was she completely eviscerated and killed Bloomberg. But that showed a quality in his DNA that I think you're seeing exhibited in this lawsuit again. Because there is no doubt that he made promises to these campaign workers to have them leave other campaigns, to leave their careers and their families, to go on the road with him, to invest in him. And he told them, he made a promise upon which they relied, that he would, regardless of whether he kept campaigning, he would keep the doors open and pay them through a date certain. And then he just reneged on it. And why he thinks that's appropriate, given all the money that he has and all the money that he spent on this folly of trying to become president, is beyond me. And it just takes away and detracts from all the other good things, frankly, that he does in philanthropy worldwide.
My prediction will be we'll hear about a settlement soon. I mean, he seemed dead to rights on the law on this one. It seems like he owes them money, whether it's contractual, whether it's fraud, whether it's an inducement, whatever theory you have.
Promissory estoppel, right?
Estoppel. He's going to be dead to rights. There's no way he's sitting for a deposition and he's going to be questioned about why he didn't pay these people who he owed. So I think this case settles very quickly.
Agreed.
Moving on to breaking news today, a case that I'm involved in, which is the NFLPA's CBA agreement with the NFL. So it was actually me working with some other lawyers and disabled players. We discovered that after the CBA vote was taken, the collective bargaining agreement between the NFL and the NFLPA, the players were given the CBA to review on March 5th. They then voted on March 14th by midnight. They announced that it passed on March 15th. We discovered that there were changes, material changes, that were made, particularly in Article 60, that basically created additional offsets related to Social Security disability insurance to disabled players, that expanded that scope, not just to players who applied for Social Security and applied for disability after January 1, 2015, but that the changes that were made after this passed occurred before January 1, 2015. So it affects a whole other set of player population who are now subjected to these offsets. Now, have you ever heard of, just in any agreements that you've ever done, after a settlement agreement, an agreement is done, just changes being made without telling the other side or people, hey, I'm making a change, even if those changes are minor?
No, that is beyond the pale of what is appropriate practice when you're negotiating with another party. I have never in 30-year career made one comma change in a document, especially one that was in final, that had already been agreed to by the other contracting party, made a change in it and didn't alert the other side that for some reason I had made the change. I mean the most minor of changes. Even if the page numbering had been changed, I would have been obligated, ethically and otherwise, to send them a red line, a track change to show them where the changes are. So if what they were trying to do was to post, what it sounds like to me is posting the collective bargaining agreement and making after the fact changes that the other party to it, in this case the players, did not agree to, unless they got a lot of explaining to do here, unless they have an explanation that they just posted the wrong document, then they've done something unethical, underhanded, and in breach.
And put it this way, we sent our letter, I sent the letter to D. Smith, who's the executive director. I sent that letter this morning around 7:30. The media started asking him questions. They've had no comment to date. I think that tells you everything you need to know. You don't go posting edited language after an agreement is done. And I've been
Especially
asked by the media, I've been asked, hey, but is it a material change? And I say, yeah,
there.
it's a
Yeah.
material change, but who cares? Even if it
There.
was immaterial change and there was two commas that may have changed the cadence of it, you still tell the person.
I was shocked when you gave me the overview and I read about it that it's not. I gave an example of something that's minor that under my ethical and professional obligations, I have to tell the other side about. First of all, I've never done it after the contract has been executed. After the
Hard. You lose your legal license.
that's called fraud, plain and simple. Okay, even if I did it in the last round of negotiations, but yours goes beyond that because you're telling me, and I understand it, that the changes that were made were substantial and material that to the detriment of the players' union on disability issues. How could they ever think that they'd be able to get away with that? It's mind-boggling.
Very strange. So going finally to the last issue, another corona-related issue, we've seen issues about Liberty University, students going back on campus, them ordering students to go back on campus, and we've seen as well, Fox News and certain commentators who have been terminated recently who downplayed the risks of corona. Do you see, with respect to either of these entities, potential legal liability for either downplaying the responsibility or by telling people that they need to actually affirmatively show up and they can get corona?
Yeah, I'll start with Liberty University. I thought Jerry Falwell's kid here has really taken leave of his senses. I've read enough about him and his background where he just doesn't like to be told what to do. Either that or he's put his faith completely in God, which is surprising to me because there's not a church in America that's in a quarantine zone that's being allowed to operate. So I don't know where he gets off thinking that God speaks to him and is allowing his university to operate and not infect.
Massages also, I heard something about that.
Well, that may be too. As I mentioned to you earlier before we got on this video, I also find just the juxtaposition of two major leaders of religious organizations and their children and how they're addressing coronavirus. You got Falwell's kid who decides that his students are going to be somehow immune from the infectious path of the contagion, and he opens the doors and immediately students get coronavirus. You contrast that with Billy Graham's kid, Frederick, who along with his organization, Samaritan's Purse, is instead operating field hospitals that have now opened in Central Park. So it's just amazing to me. One kid got this brains from the father and the other kid didn't. And I think there's a lawsuit in the making for the Liberty student population, the parents there, because he basically forced them by opening the doors to return to school. I assume he didn't give them remote or tele-learning options. He certainly didn't give them all a pass for the semester. So they're all worried about their academic credentials, and they feel like they're compelled by pressure of the leader of the educational institution to go back to school, and then they walk out with coronavirus. That is...
Even if they didn't get the coronavirus, what do you think about this? That there would still be a claim for intentional infliction of emotional distress. You even have to make that choice in the first place.
That's right. There is a group now, we didn't talk about it yet, but there is a group of students that are trying to band together to force colleges, all colleges, to give for this semester every student a pass. A pass, not even a grade or a pass-fail, no fail, a pass. And that just shows you the tremendous amount of emotional stress and psychological pressure that's landing on college students, not only in their own world, but now they're home with aged parents or grandparents that they're worried about, or younger children in their household, like their brothers or sisters, that they're having to help with homework and homeschooling on the fly to salvage a school year. I think the kids should be given a pass. I think Jerry has Falwell's kid has opened himself up to a lawsuit, both by the students who get the coronavirus, and I agree with you, intentional infliction of emotional distress.
I've spoken to students on the topic of schools. I've spoken to law students who are expecting to start jobs with me, in the coming summer and fall, who will still be working with me, but who had bar exams that are now being canceled. I think in New York, did they
Yes.
cancel the bar exam and they moved it? What's going on in New York? Do you know?
Yeah, they kicked the July exam forward to the fall, and that's going to change the trajectory of hundreds of thousands of careers. Unless they're with a mega Am Law 20 firm, they're not going to be on a stipend. They're not going to have money rolling in. They're not going to have any cash to support themselves or a job to speak of. And so I also don't think they're going to be eligible for the CARES stimulus package. So there's a whole group of people who are basically made unemployed for forced unemployment for 1 quarter or 2 quarters in their career.
And we're waiting to hear what they're going to do. The California State Bar is going to be making a determination shortly and announcing that. I think we know what the determination is going to be. I think they're going to do the same thing that they're going to do in New York. Now, I know we said we're going to talk about the liability potentially of Fox News, but we need to tease people for the next episode.
I like that one.
And so we're not going to go into that right now.
Fortunately for us, Fox does something every day that could lead to its own liability.
We will talk about that on the next episode. Anything you want to plug while we got you on?
No, I just happy to be here with you, and I'm looking forward to being a regular contributor to your program.
You got to plug the law firm.
I'll plug the law firm. So when you're in New York or otherwise and you need top legal advice, Simpano, Patricia Simpano.
Awesome. Thank you.
You're welcome. Thank you.
We'll talk soon. This was fun.
You too. Bye, Ben. Cheers.